Hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone, and welcome to this sitting of the Appeals Court. I apologize for our slightly late start, but we had some technological problems this morning with the recording system, so I'm glad that's all straightened out. It is my great honor and privilege today to be sitting with Justices Milkey and D'Angelo, and my name is Gabrielle Wolohojian. We have a list of 6 cases this morning. For those of you who are planning ahead for later in the morning, we will likely take a 10 to 15 minute break after the 3rd case. So that's just for those of you who are planning. I believe most of you have appeared and argued in this court before, but I will repeat the basic ground rules just in case. Each side receives 15 minutes to argue. If you are splitting your time, which I believe one case on the list is, please just let us know the allocation you wish beforehand. There is no rebuttal, so don't reserve time for rebuttal. The yellow light will go off about a minute and a half but before the end of your time expires, and that's to allow you time to plan on how you want to wrap up your argument. When the red light goes off, your time is over, and you should conclude your argument at that point unless we continue to have questions for you. You may assume that we have read not only your briefs, but the relevant portions of the record, so you do not need to educate us about the background of your case. Unless you wish to, I don't mean to tell you how to structure your argument. I just want to let you know that you don't need to feel like you have to bring us up to speed. We are, in fact, well, we at least think we're prepared. So with that, I'm going to call the first case, which I'm going to caution everyone is partially impounded, so please do not use the names of, it's not all names, but because the adults can be referred to, but no names of victims. And the first case is 2021 P 0482, Commonwealth versus Charles Davis. And is it Attorney Essington?
That's correct, Your Honor.
We are ready whenever you are.
Thank you. The issue in front of this court is whether the single issue is whether the prosecutor misstated the facts in her summation and whether there was a chance of a miscarriage of justice as a result of substantial risk. In her closing, the court stated that one of the eyewitnesses who testified, Natasha Lorenzen-Gaudet, described how the defendant picked the complaining witness up exactly the way the complaining witness told you that he picked her up.
Let me make sure that I understand the precise nature of your argument. As I understand it, you're not arguing that the prosecutor misstated that the witness provided a description of the events consistent with the victim's description of events. That's not the piece that you're saying is misstated. What you're saying is misstated is that the prosecutor added both the victim's name and the defendant into that statement.
Yeah, particularly it was the prosecutor stating that the witness, Gaudet, had stated that the defendant, Mr. Davis, picked up the complaining witness.
Right, but so we need to stick to the language. I think what the prosecutor said was the the witness described how, right? Doesn't say stated that Mr. So-and-so picked up Ms. So-and-so.
Yeah, the exact language was, I think, describing how the defendant picked up the complaining witness exactly the way the complaining witness told you how he picked her up.
Right. So, now, and you're not arguing that there was no evidence to support the prosecutor's use of the defendant's name in that sentence or the victim's name in that sentence. You're stating that the prosecutor misstated only that this witness didn't say it was, because this witness couldn't identify who the two people were.
That's
your
correct,
basic
Your Honor.
argument.
And not only did she not identify them, she didn't give any description of them other than stating it was a large male and what she initially believed to be a child.
There was plenty of evidence to indicate that the person who did that the defendant was the person who engaged in the conduct, and the victim was the person who was the recipient of that conduct. It just wasn't necessarily from this particular witness.
Yes, I mean, I think, I don't know if I totally agree respectfully with your first statement, but, you know, the only person who identified Mr. Davis was the complaining witness herself.
Right. But we know that that's sufficient from our case law.
Yes, and I'm not arguing sufficiency, obviously.
Right.
And I think, you know, this is maybe parsing quite a bit, but I think there's really a distinction between a prosecutor arguing that the jury should infer certain facts based on the evidence versus misstating what a witness actually testified to.
Is it your argument then that a prosecutor has to say to the jury, I'm inferring that the witness is talking about the defendant in this case?
I don't know that the prosecutor necessarily has to use the word infer, although it would be preferable, I think, but.
In this case, the facts are from the alleged victim that she described the defendant as picking her up and throwing her into the car. Then the witness is described, and I'll paraphrase a little, a big man throwing somebody in the car. You don't believe that putting those together, that a prosecutor can argue to the jury by a fair inference that the witnesses are identifying the same person as the one the victim did?
Again, I think the prosecutor can ask the jury to make that inference, and but what the prosecutor was doing here particularly was essentially, I would argue, paraphrasing or summarizing what the witnesses had testified to, and the way it was phrased didn't suggest that she was asking them to draw an inference. It seemed to be that she was summarizing what she thought the witness had testified to.
Well, what she actually said, I think your argument would be stronger, to be frank, if the prosecutor had said, Natasha Gaudet stated that the defendant picked the victim up. But that's not what the prosecutor said, correct?
She did not use the word stated.
She did not. She did not use the word stated, testified, said, anything like that. What she said, what the prosecutor said was Natasha Gaudet actually describing how the defendant picked the victim up. And it seems to me that we need to be fair here to the language that was actually used. And so I'd like to know how it is that, or why it is, particularly if we consider the two sentences that came before that in the closing, we would conclude, or a person should conclude, that the jury would have understood this sentence to be a statement about identification as opposed to a statement about describing what happened.
Well, I think if Your Honor looks, I was just trying to find the language, but I'm not finding it right now.
Well, what it says is, what did the witnesses tell you? From two people that knew nobody in this case, blood-curdling screams for help, screaming for their life, someone being hit, and then being picked up and thrown in the car. Natasha Gaudet actually describing how the defendant picked the victim up, exactly the way that the victim told you that he picked her up. Right. So to be frank, I don't know that that can be read as a statement of identification as opposed to a statement of describing what occurred.
Well, I would respectfully suggest that the beginning of that phrase, which was, I believe, what did the witnesses tell you, I think is similar to saying the witnesses stated X. And so it seems that she's summarizing what the witnesses told the jury. And that's my argument, was that that is different from asking them to infer that she identified, in fact, the defendant when she did not.
Now, identity was not really the issue here, though, correct? There was no argument by defense counsel that the person described was somebody else. It was more that the witnesses missaw what they saw, not that they misidentified.
I would respectfully submit that there was an issue. I don't know that I would argue that it was the primary issue. I think the primary issue in the trial was the credibility of the complaining witness. But as I cited in my brief, the defense counsel did make what I would characterize as an identification argument in his summation, which, you know, he noted that neither Gaudet nor the other woman had identified or even described the male or the female, or in one case a child, as described initially. And so I think he did. I think it was a live issue, and he did make an identification type argument by highlighting those facts. And again, that's in my brief.
Isn't this a case where the lack of an objection is particularly important, and that to the extent there is any bite to the argument you're making, an objection would have given the judge, or for that matter, the prosecutor, a chance to cure any problem?
Well, certainly the lack of an objection changes the standard of review for this court, so it is certainly important.
No, but the reason for that is because of the ability to cure when you raise an objection.
Presumably, yes, that is the reason. But I think, I mean, that is, we understand that there was no objection, and so then we go to the factors that are under the substantial risk of a miscarriage of justice, which already takes into account the lack of an objection.
No, I understand that, but I'm just, where identity was not really the driving issue in this case, I'm having a hard time seeing sufficient prejudice to meet the substantial risk test.
Well, turning to that test, I would argue that, first of all, we have a situation where obviously the jury did not find the complaining witness credible because they acquitted Mr. Davis of all of the charges except for these two. And so that's obviously an important factor in terms of the strength of the Commonwealth's case generally. You know, the other factors we look at, whether there was any kind of a curative instruction given, there was not. In this case, obviously, was standard instructions that arguments are not evidence, but there was no specific instruction that would have cured the misstatement in this case.
Well, I know you call them standard instructions, and you're certainly right that the judge gave standard instructions, but she gave it right before the closing argument, reminded jurors that closings are not evidence. In her big charge. At the end, she reminds them that closings are not evidence, and in fact says, if your memory is different than those of the attorneys, you are to follow your own collective memories. So isn't that curing any potential issue that you're raising now, that if the jurors remembered that that specific witness didn't specifically identify the defendant, then it's their memories that control?
Well, I would characterize that as one of the standard instructions. I mean, I've seen that in pretty much every case.
But aren't we presumed that the jurors follow the judge's even standard instructions?
Yes, there is a presumption that jurors follow the standard instructions. I'm just suggesting that under the factors that this court looks at in terms of substantial risk of a miscarriage, that the specific curative instruction factor is not present in this case. Unless there's any other questions, sorry.
Oh, thank you. We
Thank
have your
you.
brief. Attorney Kennedy?
Good morning. May it please the court, Nathaniel Kennedy for the Commonwealth, asking you to affirm the defendant's conviction. I want to start just as a housekeeping measure. I filed last night a 16L letter. I'm not sure if the court had an opportunity to see that.
How is that a 16L?
Just bringing to the court's attention a case.
To a long existing case that you forgot to cite in your brief?
Well, it wasn't that I forgot to cite it. It was just that it had not come across it in drafting my brief. And last night when we were mooting the case, a colleague alerted me to that case and said, oh, that's a similar circumstance. So, of course, it's I'm required to let the court know that that case exists, with the circumstances being so similar in nature. In that, the court found...
I think you're required to tell us about cases that go against you. I'm not sure you're required to tell us about, late discovered cases that help you.
Well, I think it is best practice to certainly alert the court to a case that I come across that has such a firm similarity and holding to the facts that are present here. I mean, the court can take that for what it's worth. They can refer to it or not. I understand that it's not in my brief, but I felt important to alert the court to. In that case, the court found that although the witness did not specifically identify the defendant, that the circumstances in the case, the circumstantial evidence that had otherwise identified the defendant, was not an improper statement by the prosecutor to refer to that witness as having seen the defendant. So again, those facts are extremely similar, but nonetheless, the case does not hinge on that case. My case does not hinge on that. The circumstances here are that there was no error in the prosecutor's comment that the witness saw the defendant picking up the victim. The prosecutor was simply marshaling the evidence to the jury and asking them to draw a reasonable inference, which this is certainly a reasonable inference to be drawn from the facts. The victim testified that she was there with the defendant, that these circumstances occurred, and the purpose for this statement was the prosecutor offering to the jury corroborative evidence of the victim's testimony. So certainly, I'm arguing there is no error in this case. So we start there. Was there error? No. The statement was, as the court has already said, Natasha Gaudet actually described how the defendant picked the victim up exactly the way the victim told you he picked her up. So the following statement that the prosecutor makes a few lines down from there is, does that corroborate the victim's testimony? Demonstrating exactly what that was being utilized for. I believe in defense argument the question was asked, doesn't that show that it was being used for the corroborative purpose? So I believe that it was. Now, context is obviously important in determining whether there was error. That's Commonwealth versus Causable, 488, Mass 575. That's a 2022 case. And then taken with the evidence and instructions, we determine whether there was error. We have the context, which it was being used to corroborate the victim's testimony. We have the instructions that were given. As Your Honor pointed out, standard instructions are still instructions that the jury is presumed to follow. Whether they're special instructions or standard instructions, we presume the jury listens to those instructions which were given here, that the closings are not evidence, the statements of the attorneys are not what are not evidence, and that the jury is to use their own memory to determine what is in fact evidence and to evaluate the credibility of the witnesses. As I pointed out, the Matos case, which was provided yesterday, all demonstrate that there was no error in the Commonwealth statement. Moving on, however, if this court is to determine that error existed, we look to a substantial risk of a miscarriage of justice. I agree, Your Honor, that it is important that there was no objection. It's important to show that there was no objection because that can give guidance as to whether that presumed error was in any way prejudicial to the defendant. In this case, no objection. No one in the room heard this and thought there was a problem with this, so we can look to that as guidance, obviously changing the standard of review to a substantial risk of a miscarriage of justice. We're looking at the strength of the Commonwealth's case. We look at the context, again, the entire closing in light of the strength of the Commonwealth's case, and whether or not there's any serious doubt whether if that error had not occurred, whether the outcome would be different. Commonwealth's case did hinge on the victim's credibility. She testified that this happened. Witnesses now testified that they had seen an event occur similar to the way the victim described it happened. I would argue that is strong evidence in support of the Commonwealth's case. We then can look to, lastly, the fact that the defendant was acquitted of the most serious charges and a greater number of charges. So he was acquitted on 7 charges, convicted on 2. The charges that he was acquitted on took place separate and apart from the events that occurred that the witnesses testified to that they saw out the window. So they saw a series of events occur. The victim had testified to those series of events occurring. There was corroborative testimony to the victim. He was convicted of that.
Which seems to suggest that the jurors placed significant weight on the fact that the victim's testimony was corroborated by these 2 witnesses.
Certainly. I think that that is the corroborating
So
factor.
how does that help you?
Yes.
How does that help you in the substantial risk analysis?
It doesn't, because it goes back to whether or not
Because it's
this-
not a case where, they testify about all the crimes and the jury acquits of many of them. And so then you could make the argument, well, look, they weren't particularly swayed by this statement because they were still able to acquit on the majority, but these were the only 2 charges that these 2 witnesses testified to.
Right.
So it seems to indicate that the jurors placed weight on these 2 witnesses' testimony.
Certainly. I absolutely agree. Corroborative testimony is powerful, it's impactful, and I think we can read into that, the fact that
Right,
those...
so maybe I misunderstood your argument, and I thought you were saying that that particular fact that they were acquitted, that the jury acquitted the defendant of many of the charges helped the Commonwealth.
It goes into the substantial risk analysis. of whether
Sure,
or
but
not
in this
these
case,
prejudice
how, when these are the only 2 charges that these 2 witnesses testified to?
Again, taken in context for how it was offered for corroborative, for credibility, supporting the credibility of the witness. So let me pause for a moment and think of Your Honor's question and make sure that I answer it correctly. I was indicating that the fact that the defendant was acquitted on the greater offenses shows that the jury was able to take at value the evidence that was put before them, that they were able to listen to the instructions, weigh the evidence, weigh the credibility of the witnesses and the victim, and determine what they believe to be true. And so what I'm saying is that the jury got the answer right, because they were the ones who were instructed on how to use the evidence, and where there was, if they did not have corroborating information for the other events that occurred, they were following the instructions of the judge and doing what they were told to do, which is to evaluate the evidence which they thought was most impactful, beyond a reasonable doubt, to find the defendant guilty. So I'm saying that that is useful to show that they did what they were told to do, evaluated the evidence appropriately, and found the defendant rightfully guilty. And that the one line that the prosecutor referred to as the witness saying that they described how the defendant did this action similar to how the victim told you she did it was simply that, to draw a reasonable inference from the evidence that the defendant was in fact the perpetrator of the crime. I think that answered the question. It was a little bit of a roundabout way to get there, but I think that helped to clarify that question. Hopefully.
Since this is the one crime that the jury convicted him on with corroboration, isn't it important that a prosecutor be very specific in arguing the actual facts as opposed, or telling the jury that they can infer the facts?
I don't think that that's a reasonable ask of a prosecutor, to be frank. I think that we cannot ask, that would be unnecessarily parsing out exactly what was said here and saying that, and really applying a hyper-technical analysis to it, which we're not supposed to do in.
Would your argument change if she had said the witness said the defendant did this?
I think that would weaken my argument, certainly. I think that would, if there had been more of an implication that this was somehow an identifier, that this is, the witness said the defendant was this person outside the window, that would weaken my argument. But that's not what happened here. What we have.
So an inference is okay,
Inferences are certainly okay to be drawn from the evidence.
even if it might be a misstating of the evidence.
This, I don't think, was a misstatement of the evidence. This was, as Justice Wolohojian stated in the first question, wasn't this statement just a further offering of a description of the events as they occurred? This wasn't an affirmative statement. This witness said the defendant did this thing. She described how the events occurred, similar to the way the victim described them. There's no other questions?
I think we understand your argument. Do you have anything further to add?
I don't believe so, no.
Great, we have your brief. Let me see if there are any other questions. Let me see if there are any questions. No. Okay, thank you. Thank you both. And the case is submitted. The next case is 2022 P1081, Commonwealth versus, I don't want to mispronounce the name, Guilherme Pereira. Please correct my pronunciation. And Attorney Jellison, we're ready whenever you are, but don't feel rushed. I've been told I don't spend enough time between arguments before I call people up.
I'm ready as soon as the green light turns on, Your
Okay,
Honor.
let's give it a second.
Good morning, and may it please the court, Eva Jellison on behalf of Guilherme Pereira, who is present in the courtroom behind me. I'd like to focus on the ineffective assistance claims today, which raise fairly 3 performance errors.
Okay, before you get to the errors, can we deal with one important housekeeping matter?
Absolutely.
There was a large compendium of documents that were appended to your motion. Then there was an evidentiary hearing at which, as best I can tell, one exhibit was taken, but the parties seemed to share an understanding that all the documentary evidence that was submitted with the motion was properly before the judge who held the evidentiary hearing. Is that correct? And assuming it is, what are we to make of these documents where there isn't a key to what they are, where they came from? And frankly, I'm thinking in particular of the notes from the social worker, which play an outsized role in this case.
So it was my understanding at the hearing that when I offered the first document as an exhibit, the emails, that the prosecutor's response indicated to me that she agreed that all of the documents that I had appended to the motion were properly before the court. To the extent that the court feels like we need more information and that these documents were not properly before the court, I guess I would suggest a remand to get them properly before the court, but that was my understanding at the hearing.
No, I don't think that's quite Judge Milkey's question. It's not about whether they're here properly. We're just trying to find out, were they before the judge below?
Yes, they were before the judge below, and he actually specifically relied on the social worker's notes.
I know, we saw that. So how do we know that they were, other than inferentially, how do we know? Were they submitted to the judge at the hearing but not marked as an exhibit? How did they get in front of the judge?
Yes, they were an appendix to my motion for a new trial, and they were before the judge in that way.
Okay. So perhaps it makes sense for you to just file with us as a supplemental filing the document, a copy of the document that was submitted to the judge down below.
Absolutely. My record appendix contains the contains the record that I filed with the court, but I can make
That's,
clear.
or you can just send us a letter
So, I
giving
mean,
the,
we have the redacted version of the documents.
Right.
Was there any introduction, an affidavit introducing these documents? I mean, they just appear in front of us.
They were described in my motion and relied upon in that
and
way.
your motion is, just tell us the page if you don't mind, if you
Yeah.
know it off the top.
Let me just hit.
You have
get to my
impounded.
record. Let's see. Motion to withdraw guilty plea is at record 142. Legal arguments in support of the motion are record 144. Then there are the replies to that. And, I think I can just make clear that the way that I put this in the appendix, I understand where the problem is. I didn't state that this was the appendix that was appended to my motion, but it was, and I think I can make that
Well,
clear.
in the table of contents, I think you do.
Okay.
It says
okay.
impounded appendix to the juvenile's motion to withdraw plea with repeat documents.
Yes. Yes, so there are portions of it, repeat documents omitted, yes.
So to echo Judge Milkey and Judge Wolohojian's comments, you believe that just because they're appended, that is evidence that we can use, even though it wasn't properly introduced, even though just because it was appended, that's good enough?
I think that where the Commonwealth agreed that these documents were already on the record during the hearing and the judge relied upon them, that you can also rely upon them. Does that address that question to the extent that I can, Justice Milkey? Yes. Okay. Then I'd like to move on to the ineffective assistance claims, and I raise 3 performance errors. One is that the advice that counsel provided was deficient. The second is that the way that counsel provided the advice was deficient. And the third is that the totality of the way in which he treated the immigration issue was deficient. So I would say that those are 3 separate performance errors.
Can you list those for me again one more time?
Yes. So the first 2 are Padilla errors, Padilla and its progeny under Article 12. And one is that he provided deficient advice. One of them is that he provided the advice in a language that the client could not comprehend. And the third is a more totality argument having to do with counsel's entire performance on the immigration issue. So I'll talk about the advice first. Counsel is required to advise a client if he is losing a substantial, viable opportunity for discretionary relief. Counsel didn't do that here. Mr. Pereira was here as a visa overstay. He was therefore admissible, and he had a very easy path to relief. By pleading guilty and admitting to these crimes involving moral turpitude, he rendered himself inadmissible.
Why was counsel's advice deficient when, according to the social worker, he basically told the defendant or the juvenile, assume you will be deported?
Right.
That's correct, isn't it, in what ended up happening?
It's correct, but it's too broad. It doesn't let Mr. Pereira know that he has this viable opportunity for discretionary relief that he is specifically giving up by taking this plea. And moreover, there's a second part.
Can I just paraphrase what I think you're saying, which is it may have been largely or essentially accurate with regard to the immigration effects of a plea, but without comparing that to the immigration effects of going to trial,
Absolutely.
the advice doesn't mean anything.
Right, and that was going to be my second point, that it wasn't specific enough to Mr. Pereira, to Judge D'Angelo's point, and my second point was going to be that he didn't discuss the consequences of going to trial. So without that decision point, that very important decision point of do I go to trial or do I take this plea, he doesn't have enough information for that. And he doesn't know that there are ways at trial where these consequences wouldn't have happened, where he shouldn't have assumed that he would have been deported because he wouldn't have faced those consequences with an acquittal or adjudications of assault and battery.
But can we, time is short, so can we jump to the first prong of the prejudice piece?
Absolutely.
On the option of going to trial?
Yes.
And I understand that trial counsel was exploring the hazing expert and making that a prominent part of the trial, I have a hard time understanding the import of that. Certainly, it has great relevance to things like sentencing, but in terms of the kind of intent that needs to be proven in a rape case, in a assault with intent to rape case, in an indecent assault and battery case, I'm having a hard time understanding why you think there was any appreciable chance, had this gone to trial, of getting a conviction for less, for a simple A and B. And let me just leave you with the thought that we seldom see sexual assault cases where there are 20 witnesses, or however many there were here, 20 eyewitnesses. So, I mean, it's unimaginable that there wouldn't have been an assault and battery conviction, and it's hard to conceive of something being less than indecent A and B.
So I'd like to answer your specific question, but don't let me forget to get back to the standard of what a substantial defense is. So for your specific question and why the hazing mattered, in the case law, it says that you have to have a sexual intent for it to be indecent assault and battery. And I think with the hazing...
You have to intend to do what you did, but are you saying that if, you know, say in a rape case, there was a physical acts that constituted a rape, and you hire an expert to say, but there was no sexual motive here.
So
I did what I did for other reasons.
So I don't think that that would apply to a rape case, but it's my reading of Commonwealth versus Kennedy, which is 478 Mass 804, that indecent assault and battery does require a specific, it requires a specific sexual intent. And I believe a hazing expert could have helped, or could have testified that that's not really what's happening with hazing. Moreover, you noted that there were so many witnesses in this case. The witnesses in this case differed substantially in terms of the facts that they reported. Not on each of the boys, but there were differences and there were discrepancies in the facts that were reported by several of the different boys. That alone could have been reasonable doubt. But I really want to take it back to what the standard is here. So if you look at, you don't have to prove that your defense would have been more likely than not to succeed. You don't have to prove that your defense would have been likely to succeed. If we look to Commonwealth versus Lease, you know, this is a totality of the circumstances analysis. You can look at the fact, you can look at special circumstances in concert with the substantial defenses. So if we look to Commonwealth versus Lease, it says there may be even a small chance of acquittal or a small chance of, in this case, a conviction of assault and battery or an adjudication of assault and battery, and that would be enough for prejudice under this specific standard. So I think it's a little different than our normal ineffective assistance claims. It really goes with Clark and its progeny. And I cited to this case in my brief, but I didn't cite to this section of it. In Lee versus United States, the United States Supreme Court engages in a discussion about whether or not it would be rational to go to trial when you really only had jury nullification to rely on. And the court said yes, and it's a special circumstances case, but here we're looking at a totality of the circumstances, and Gill also had special circumstances. There was no question, and no opposition by the Commonwealth, there was no question of fact that Gill arrived here when he was, do you have a question?
How does any of this matter when it appears that the judge credited the evidence that the juvenile was informed of the immigration consequences and said he understood?
So
because how do we get around that?
So I mean, I think there are several answers to that question. And I can go back to the advice. If a client understands advice that isn't complete and isn't specific to him and isn't actually correct, that shouldn't matter. It's the advice that matters.
But I don't quite understand in what way the advice about the, because I think we have to be careful here about what defense counsel's obligations are. Mm-hmm. They have the obligation to inform their client of the potential immigration consequences of their plea. I've never seen a case that says they have all the duties of an immigration lawyer hired separately to provide immigration advice. I've only seen cases saying they have an obligation to provide accurate advice about the potential consequences of the plea.
Right,
And here, I haven't heard what the lawyer said that was incorrect, unless you're drawing a distinction between deportation and inadmissibility. So that's where I thought you were going, which is that, sure, the lawyer told the client, you should assume that you're going to be deported. It's unclear, but you should assume that you're going to be deported as a result of this. But he didn't tell him, oh, and then you're also going to be inadmissible should you seek to return. I thought that's what that was the thrust of your argument. But now I don't understand that that's the thrust of your argument.
So it's part of it, but it's both what you've just stated and what Justice Milkey keyed upon, which is that counsel didn't give him the specific consequences of his plea, and also didn't give...
What consequence did he not give him?
He didn't talk about the admissibility. This was essentially...
Inadmissibility.
This was essentially... I'm sorry. Well, admissibility and admissibility.
Sure.
He didn't talk about the admissibility, and essentially this is too broad.
Oh, what case do you have that says telling a client that they will be deported is insufficient? They also have to, the lawyer also needs to say, and you will be inadmissible. Is there a case where anyone's said that?
So I don't have a specific case that says exactly that. I definitely don't. But I think that if you look at Lavranenko, which says that counsel is obligated to talk about losing a viable opportunity for discretionary relief. If you look at Marino, and you look at a case that I cited, United States versus Giamo, where counsel is obligated to tell the client what going to trial what they would face in going to trial in terms of immigration consequences. I think that's really where he falls down here.
Did the advice from CPCS say anything about admissibility?
It did say something about admissibility. I'll have to say, so this is where counsel's entire performance really comes into effect. He contacted the IIU, may I continue?
Yes.
He contacted the IIU shortly before all of this plea was set to take place, and he received advice from the IIU about 5 days before. That advice was a little complicated, and it talked about inadmissibility. It also raised...
What did it say about inadmissibility?
I can read it, it's kind of long. Do you want me to?
Does it say that the
It said that he was
juvenile would be
risking-
inadmissible?
It did say that he was risking inadmissibility with convictions of these CIMTs. So it did talk about admissibility in that way. And it also raised red flags. When counsel, he writes back, he gets this advice. He writes back and he says, we have a plea to assault and battery with a dangerous weapon and an indecent assault and battery. And IIU writes back, watch out, those are still crimes involving moral turpitude. So, I mean, I think at that point, this is where doing this so late, already crafting the plea, giving it to the Commonwealth, agreeing to it, having Gil take 2 months to get used to it, then reaching out to IIU, getting complicated advice that raises red flags, going to Gil 3 days before he expects to plead guilty and explaining it to him in just one way, using a word, if you credited him, that he didn't understand, but explaining it in one way to a depressed, anxious juvenile who also had the cognitive task of then translating things to his parents. In some ways, this is kind of, it goes to both my argument that this was provided in a language that Gil couldn't comprehend, and also to kind of more of a totality. Counsel never went back to the Commonwealth to say, you know, I'm sorry, we have these immigration consequences. So just, I know I'm out of time.
No, I had a question about that, actually. Do you have a case that imposes on defense counsel an obligation to raise the potential immigration issues with the Commonwealth?
You know, I want to say there's more than one that I would point to. The one that comes to mind is Marino, where, and I think specifically in Justice Duffley's concurrence, where she really speaks about that the Commonwealth has kind of this obligation to do justice as well.
Sure,
And
but my question was a little bit more specific.
Yeah.
At least I tried to make it
I-
so.
I would be
Which
happy
is
to
there any case
provide
that
that.
imposes on defense counsel an obligation to inform the Commonwealth of immigration consequences?
let me say I'm not exactly sure, and if I could get you that, if I find it.
All right.
I would appreciate it.
Let me,
What evidence, if any, is there in the record on prong 2 of the prejudice issue? Namely, could he have negotiated a better plea agreement?
So the evidence that I relied on, and the judge didn't comment on this at all, but the evidence that I relied on was that the Commonwealth later was very open to, once counsel provided an evaluation, didn't oppose sex offense registration. And that said to me that there may have been more opportunities for cooperation than defense counsel sought. So that was the evidence that I was relying on.
But there's also the no pros of the third defendant.
Yes. Yes.
let me, do you want to say a couple words about your knowing and voluntary argument?
Absolutely. So I think what I would say about that is that the judge did not find facts on Gill's subjective understanding of the immigration consequences, and that's why I believe that remand is necessary for that, because in Najjar, it says that a defendant needs to know the direct consequences of his plea, needs to subjectively know the direct consequences of his plea, and the judge did not find facts that would allow us to.
Why
have that.
doesn't the social worker's notes blow you out of the water on that, where we have a contemporaneous look inside your client's mind as to what he is thinking at that time?
Well, my client testified that he didn't understand what the word deported meant, that he had already come to terms with this, and that he was just being, he was just trying to be agreeable with his attorney. And I also presented evidence from a social worker who talked to Gill, read his records, and learned other information about this case, who also said that it's not necessary, that you could come to the conclusion that Gill didn't understand even though he said that. And I would also point the court to Gill's educational records, which indicate that he struggled in high school. He hadn't passed any high school English courses at that point. He was a person who spoke English as a second language. So I would point the court to all of that to say that the judge could have found differently, but there are no findings on this, so that's why I believe that remand is necessary.
Do you have any questions? No, thank you.
Thank
Thank you
you.
for your argument. Attorney Sadlon?
Good morning, Justices. My name is Patrick Sadlon, Assistant District Attorney from the Berkshire District Attorney's Office, representing the Commonwealth. If you get anything from the Commonwealth's position here today, is that the defendant received constitutionally effective advice, end stop. This is based on a substantial evidence that there was advice. We do not have to guess about kind of what advice was given. As Justice Milkey pointed out earlier, we have a contemporaneous view of what the
Can I ask you about the advice here?
Yes.
Let's assume the advice at best was, assume you will be deported. Can't every defense counsel say that to every defendant who has immigration issues, and you think that covers all the Clark problems, even if it's wrong?
I believe that saying you presume you will be deported is effective saying you will be deported, which is different than the eligible for deportation advice that was in De Jesus. This was not advice that was in a vacuum. This was plea counsel's advice that was given to the defendant that was in conjunction with a CPCS Immigration Impact Unit, Jennifer Klein at the time, which in a detailed memorandum outlined the consequences of his plea. And even before that, this was not a last-minute decision that the defendant was, they were given this detailed memorandum, defense counsel, plea counsel was given this detailed memorandum and then rushed their client a couple days before. The defendant...
Was there any evidence that the memorandum from CPCS was provided to the juvenile?
There's no evidence that I know of, but I do know that in the social worker notes that the defendant, with the defendant's own immigration attorney, in addition to plea counsel, were coordinating at least 4 different times back in January, which is months before the plea. We also know that the defendant was translating some of these discussions between his plea counsel and immigration attorney in part. And at that time, he was not during these plea discussions, he was not a juvenile at the time, he was then an adult. And I believe that in conjunction with the judge's decision that I understand it's hard to imagine that the defendant did not know what the word deportation meant. He had received a notice from the immigration court that he was on notice for removal proceedings, that he had gotten almost a full panoply of advice from his own parents' immigration attorney, from the CPCS immigration unit, through plea counsel, and his own plea counsel. It's hard to imagine that he did not know what the word deportation meant and did not have a full understanding of the plea, as was also dictated in the social worker
Counsel,
notes.
if you assume that the advice about the immigration consequences of taking the plea were either accurate or even more pessimistic than they had to be, how can someone understand the immigration consequences of pleading guilty without understanding the immigration consequences of not pleading guilty? And the attorney was asked point blank at the evidentiary hearing, did you ever discuss the immigration consequences of going to trial? And the answer was no. Is there anything in the record that cuts the other way, that suggests that the defendant had an understanding of the immigration consequences of not going to trial?
I believe that, and I don't mean to play an outside role of the social worker notes, but they are a good grasp of understanding what was going on at the time, because frequently in these types of cases you don't have that information. But here, the defendant seemed to be happy about the potential outcome of the plea and not facing state prison time. And I understand
that doesn't mean he understood the immigration consequences at the time.
I believe the fact that he was on notice from the immigration court, that he, I understand what you're saying, that was he apprised of the consequences of going to trial, but given the potential penalty of a life felony, the fact that he ended up only getting a 3 to 4 suspended state prison
Can we stop on the life felony and just pause? There was medical evidence of no penetration here. Weren't the chances of an actual rape conviction pretty small?
I don't think so, Your Honor. I mean, there was, and I wanted to highlight the strength of the Commonwealth's case, which was, although we didn't have, there was a video of the incident, we didn't have the actual video, but we had thumbnail images that were taken by the forensic team that detailed the defendant, the victim bent over, the defendant over the victim, holding the broomstick, in addition to forensic evidence of blood that was taken from the cabin floor. I would say that's at the very least very strong circumstantial evidence of a rape in this case. But again, to address, I know one of the defendant's arguments is that, oh, well, they would have used a hazing expert. But if you take it as, we're very confident that it would have been at least an indecent, and that is a general intent crime.
How do you address the Kennedy case that Ms. Jellison has cited? I think it was the Kennedy case that dealt with the sexual intent, according to her.
I would say that's wouldn't be accurate. It's a general intent crime. It doesn't matter. I mean, you need intent to do the crime, as was suggested earlier, but I don't believe that we needed direct evidence and that there's very strong circumstantial evidence in the case, in addition to a cooperative victim, in addition to numerous cooperative witnesses at the time, all would have had, at the very least, a very strong case for indecent, but we also believe it was a strong case for rape as well.
Can we go back to Justice Milkey's question about when a defendant, or a juvenile in this case, is deciding whether to go to trial versus a plea? The considerations are the strengths and weaknesses of the case and what the consequences are. And you keep talking, well, you've mentioned jail a few times. Isn't it appropriate for defense counsel to advise the defendant, the juvenile in this case, you might be convicted of assault and battery only, and if you're only convicted of assault and battery, you will not be deported? Isn't that proper advice, as opposed to not mentioning anything about what will happen if you go to trial and you're not convicted of these versus assume you will be deported?
I would say that is certainly a better, that's more precise language, but I believe the standard is that of what we're here today is whether the advice was within the legal obligation of the plea counsel at the time, not for any potential immigration. I believe there's no case that says a defense lawyer has to be in the purview of every immigration consequence of every possible decision at trial.
But defense counsel does have to advise a client of potential consequences. For example, if you go to trial, you're facing life on this charge, 10 years on this charge, 2.5 years on this charge. When you're dealing with somebody who has immigration consequences, don't you also have to advise him of the consequences of each one of those charges?
I would say it depends. I mean, it depends on how many charges there are. I would say that here we got a detailed memorandum from CPCS that was conveyed to plea counsel outlining in the very best case scenario of a simple A and B, which in the Commonwealth's opinion would not have been an accurate outcome of the case. There's no, defense attorneys aren't required to be immigration experts. If there are clear deportation risks, they have to convey that. What we have here is a memorandum from CPCS saying that the immigration consequences were unclear, and we also have...
If you drill down on that, they were principally unclear because it was unresolved at that time whether a youthful offender conviction was a conviction for purposes of federal immigration law. And that was the principal focus of the memo. Tell me how I'm wrong, but it turns out that that wasn't the real issue in front of the immigration judge, who said it's not a conviction. Oh, but since it was admitted, end of story.
I believe that the eligibility for admissibility or inadmissibility or deportation falls outside especially in regards to inadmissibility, falls outside the purview of what advice defense counsel was supposed to give. I mean, in this case, it seems that they did all the right things and had full-length discussions with multiple people, including the defendant, which also goes to the defendant's subjective knowledge for their intelligent plea. And that, again, goes to the Commonwealth's main point, is that the defendant here received constitutionally effective advice. There's a lot of evidence of that in this case, and we don't believe that we even get to the prejudice prong at all.
Well, can we, since the judge relied on the prejudice prong in the end, can we talk about prong two? There wasn't a lot of evidence on the option of a better plea deal, but there was the talk of the no pros for the third defendant, and as Ms. Jellison points out, there was the agreement ultimately on the SORB consequences. You assert in the brief that it's inconceivable that the Commonwealth would have agreed to an A and B here. Why is it inconceivable, especially where they're willing to null pros a case against someone who may not have been as culpable, but certainly was, from all appearances, directly involved in the assault?
It's my understanding that that null pros was for, and I don't want to get too deep into the weeds of what the, of that aspect of it, but I will say that the Commonwealth was very confident in the strength of their case and that the null pros had nothing to do with whether the defendant here, there's enough evidence to prosecute. We do have the prosecutor in our office at the time, in our office currently, and there's no indication that we would have amended down these charges without these plea discussions, or we wouldn't have fully prosecuted the case and confident that we had good evidence.
How is, this is a more global question, how is someone in an evidentiary hearing supposed to address prong 2? Do they put an ADA in charge on the stand and talk about what settlement policy is? What?
I believe that, as the case here, you'd argue the strength of the evidence, the possible defenses. I believe that they, again, the defendant mentioned hazing experts, and I believe they had a Ms. Claudia Dunn that testified at the hearing as far as adolescent brain development. I believe, other than reasonable doubt, I'm not sure, hazing isn't a defense to these crimes in the Commonwealth's opinion. There was a full-fledged weighing by the motion judge at the time where they did, list the testimony that was given at the hearing, and ultimately decided that the defendant had received competent advice and that we did have a strong case. I don't think that, and I understand that, and the Commonwealth concedes that the Hassan case was incorrect to cite. But if you take Hassan out of the equation,
how can we do that? If the judge made an error, started with an error of law, and then decided after acknowledging his error of law that this was knowing, while misunderstanding the law, why wouldn't that have to go back?
I believe, and I believe I talked about this in my brief, that Hassan is mentioned in sort of the preamble legal section of his decision, but then he goes on to talk about Padilla and De Jesus and Clark. And if the judge had simply just said immigration consequences through Hassan are collateral, all that's needed is the immigration warnings, and then reach their conclusion and analysis that way, that would be a totally different story. But what we have here is a very thoughtful analysis of the same facts that would have been waived, and I believe that even under, the conclusion would have been the same. And the appeals court, I believe, can find, even if they use a different legal ground, they can come to the same conclusion. But here, he's relying on sound cases for the analysis of the first and second prong of the Safarian prongs, and that he references Padilla, De Jesus, Clark. In analyzing this, he analyzes the credibility of plea counsel given at the time when during the evidentiary hearing, when plea counsel was asked about these social worker notes about the effectiveness of his advice and presuming you'll be deported, he then says, I don't remember, after previously testifying that he did not give effective advice. So I believe that the judge made the correct credibility determination in addition to the testimony from the social worker and from the Commonwealth, and looked at the evidence that was provided in the defense counsel's exhibits attached to her memorandum at the time, and made an appropriate decision.
I have a question going back to the second Clark factor. Am I correct that if we were to look at the possibility of a different resolution of the case, that an ABDW, an assault and battery with a dangerous weapon, would have carried the same immigration consequences of the plea that actually was entered into, even if you hadn't pled to the indecent A and B?
I believe that it would have had similar immigration consequences. I rest on, I'm not sure if I addressed that particular point in my brief, but the immigration court has a broad discretion in analyzing whether someone's deported. I know there are clear offenses like drug offenses or sexual offenses that are clearly in deportation risks.
I inferred that from the fact that it seems to me that the juvenile is arguing that he would have been able to have been either convicted or pled only to assault and battery, not assault and battery with a dangerous weapon, but assault and battery. But well, I guess we'll just have to leave it there because your time has expired. Let me see if there are any other questions. No, thank you.
Thank you.
The case is submitted. The next case is number 2023P0413, Commonwealth versus Lamont Johnson. And just for those of you who have come in since I made comments at the beginning of the sitting, we will be taking a short 10 to 15-minute break after this argument. And Attorney Mauer,
Yes.
Mauer, we're ready whenever you are, but don't feel any rush.
Thank you. May it please the court, Mr. Johnson is asking that this court remand his case so that the trial court can conduct a motion for a new trial, because the trial court abused its discretion by failing to find that substantial issues were present. To begin with, I just want to drill down on why the expert's opinion in this case was uniquely different than the many other cases in which Dr. Stephanie Block and experts like her testify. Because the failure to understand that, both by trial counsel and the court in its decision in this matter, are the reason that we're here today. So
I just want to make sure that I understand the theories at trial, of the trial, because I didn't read the entire trial transcript, but I did read sort of the later part of it. It's my understanding that the defense was that the child victims were lying, not that they had imperfect memory or that they were confabulating, but that, confabulating memory, but that they were lying for, at some point in the closing, I think the defense counsel said, well, you don't need to really decide why they might have been lying, but here's one possibility, and gave the theory about aiding the mother of one of the boys with a custody issue.
yes, that's correct.
So, all right, how would, that's helpful to me, because when I understand that framework for how the case was tried and the theory of the case, and that's consistent with the defendant's own testimony, right? The defendant placed at issue in the case the idea that you either, this is all false, or, this is true. How is it that a memory expert would have helped in that defense?
So there were two types of inconsistencies in this case. There were prior omissions over time. The child witnesses gave, evolving stories of what happened, and adding more details over time, which can be explained by what we typically see Dr. Block testify to, delayed disclosure. But she also testified that when there is traumatic memory formation, and gave the stereotypical example of gunpoint or weapons focus, that memories actually get implanted incorrectly because trauma confuses us essentially in that moment of high high trauma. So what the prosecutor was able to do and what the jury was able to infer then, these other set of inconsistencies, which were wildly inconsistent versions of events that the child witnesses shared, could also be explained by traumatic memory formation. The fact that their stories were so divergent could not be explained away.
I understand all that, but I still don't understand what is the expert that you would have been able to call who would have said, this is all caused by lying? Because an expert on memory formation, I don't see how it would have helped your defense, because it would have said their inconsistency, memory can be unreliable. But it wouldn't, an expert, I don't think, would have been able to say, witnesses lie.
Well,
You know?
there would not be an expert for the defense that would say that. However, what our witness would have said was, memory formation, traumatic memory formation cannot explain away the inconsistencies between the witnesses in this case, stripping that explanation from the jury and the prosecutor. So the prosecutor not only...
Would that be an admissible opinion?
Yes, so
How would that be admissible?
what our expert would have testified to is that traumatic memory formation, yes, in heightened trauma, there sometimes is a failure to implant correct or the accurate memory. But as we know from the identification cases, memory formation in a traumatic setting is a bell curve. And when we're not paying any attention at all because there's no trauma, we're just walking around in our regular life, we don't always remember details. When we're in high trauma, we don't always remember correctly. But when we're slightly alerted, we actually have better and more accurate memories. And so that information that is admissible already in identification cases and that Dr. Block testified about, just not completely. She never talked about how actually there's some points of memory formation when we're only slightly elevated that make us remember better. And in this case...
Are you saying that the defense would have been that the children's memories are imperfect and not that the children's testimony was manufactured?
No, the defense would have been, we know they were lying because their testimony itself was that they were not in a heightened sense of trauma when these events happened, so they could not have had traumatic memory formation. In fact, if anything, their memory should have been more accurate than what you would expect in a traumatic situation, and therefore the inconsistencies between them cannot be explained away by Dr. Block's testimony. So you cannot take Dr. Block's testimony about traumatic memory formation to mean anything when you're trying to analyze why one witness's story is completely different from the other witness's story about the same events.
So Dr. Price basically would have rebutted Dr. Block's testimony about why these children's memory, why they have inconsistent statements.
Correct. And it's really the traumatic memory formation which is particularly important in this case where we have multiple victims who shared the same experience, which is not the kind of case that often Dr. Block testifies in. She's testifying normally in a delayed disclosure case. And I think when you look at the court's decision that her testimony was peripheral, that may be true in many of the cases that the trial court has seen with Dr. Block's testimony. But in this case, it was very important to strip away that inaccurate testimony about traumatic memory formation in order to show that that science can't explain why these two children have such dramatically different stories about what happened. And it would further the argument that they were lying for whatever reason.
But so I guess you're saying if the defense wouldn't be different, you're saying the defense wouldn't have been different, but that is the test under Safarian on the second prong. If then the defendant was not deprived of a defense, that was the defense at trial.
Well, it's not that the defense has to be completely different. And, you know, if you look at...
Right, but it has to be deprived of a viable defense. And the defense was viable. The defense counsel, built the whole case around that defense. All of the cross-examinations were focused on that defense. all of these inconsistencies were developed and, argued. So how do you meet the second prong of Safarian?
Well, I would argue that even in Millian, the shaken baby case, defense counsel knew that that was his defense. He just didn't think he could get funds to hire an expert. So he attempted that defense on his own, but was still found to have fallen short under the second prong, under the first prong of Safarian. Here, defense counsel certainly was trying to highlight the inconsistencies, but he himself didn't understand this distinction. And so he brought out all of these omissions that were actually, prior inconsistent statements by the witnesses that could be explained by Dr. Block's testimony, instead of perhaps focusing more, the jury's attention more on the differences between the witnesses' testimony, because that's, if he had highlighted that with the assistance of Dr. Price, or at least through a more thorough.
How would he have done that? Because the witness, had your client put on an expert, can't comment that, oh, this witness is inconsistent with that witness. Don't they have to speak in more generalities and have counsel try to tie it together in closing argument?
Yeah, so he could either have used Dr. Price's assistance to cross-examine Dr. Block about the way traumatic memory formation is actually understood, the full bell curve, and the studies behind that. He also could have highlighted in summation then, look, here's the witness's testimony about the sexual assault. He says that, basically, I'm summarizing, but that it was not traumatic at the time. He thought it was weird, but not necessarily traumatic until he several years later. So when the memory was formed, we have evidence that he was in the middle of the bell curve. So our expectation should be that the memory was accurate. That's impossible when we have another child who's also giving us testimony that he would have been in the middle of the bell curve, and his testimony should be accurate, but they can't both be accurate given what the testimony was given here. So even just highlighting that for the jury would have taken away their assumption that, oh, you know what, because this is a very hard kind of case, and the jury is understandably going to want to, their sympathies lie with the child witness if they believe them. And so if they have a reason to explain away the inconsistencies, I think it's inevitable that they will do that. And defense counsel failed to parse that for them, why they can't rely on Dr. Block's testimony in that way.
Is there anything further you'd like to add?
If there is nothing further from the court, I will just say that the discussion that we had here, I think, highlights the fact that this was not fully aired at the trial court. We are simply asking that it be remanded so that we can have this argument in front of the trial court. Thank you.
Thank you. Let me see, there any further questions? No. Okay, thank you. Attorney Payne?
May it please the court, Cynthia Payne for the Commonwealth. The Commonwealth is asking this court to affirm the judgment of conviction and the trial judge's order denying the defendant's motion for new trial. Here, the issue is whether or not defense counsel, trial counsel's strategic decision to not retain an expert was manifestly unreasonable.
How can it be a strategic decision when he says he didn't even look? How is that strategic?
Your Honor, I would suggest that case law, Ayala, Henderson, indicate that whether or not a decision to retain an expert is squarely within the realm of a strategic decision.
How? I mean, I can understand not putting the person on the stand, depending on what they would say, but in terms of the consulting, how is it ever strategic unless we're talking about a finite amount of money and you got to use it in different ways?
I would suggest that in Ayala, defense counsel indicated that he never even thought of hiring counsel, and the issue was that it was the fact that he did not obtain funds. Same thing in Henderson, and I would suggest Henderson is a very good case for the Commonwealth. It's The motion judge, who was not the trial judge, found it was not ineffective.
Well, it may not be ineffective, but we're trying to figure out how it's strategic.
But again, it was, again, in Henderson, it was also the decision not to obtain funds. The court has found that. And here I would suggest that this was not summarily concluded. Here, trial counsel was made well aware of Dr. Block months before, the Commonwealth's expert, months before trial. He looked at a transcript of her testimony at trial, looked at several of her studies. The Commonwealth's motion to admit to the expert's testimony was for generalized testimony. This was not an expert who was going to render an opinion. This was not the Millian case where the Commonwealth relied almost exclusively on the expert for the evidence. Here, there were two individuals, two victims who testified what the defendant did.
But the Commonwealth's expert was important to the case because it explained why these children's memories made their stories inconsistent. It explained inconsistencies as opposed to the defendant's argument of they're just lying. That's pretty important because it's hard to get jurors to accept that kids lie.
Your Honor, I would suggest that the expert did concede that children lie. The expert also conceded that sometimes children recant.
But she gave an explanation as to why these children might be wrong as opposed to lying. And that's what Dr. Price's testimony would directly refute, wouldn't it?
I would suggest, again, going back to at the time the decision was made, because hindsight, we
I
can't
agree,
use hindsight.
hindsight's 20/20, but he didn't even look. He didn't look to see whether there was any expert out there that could refute Dr. Block's testimony. He looked at her prior transcripts and said, oh, this makes sense. I'm not even going to look.
Because Dr. Block was to testify in generalities, and because there were so many inconsistencies, trial counsel, as the motion judge, who was the trial judge, found that that this defense was, in the judge's opinion, the best defense that could have been proffered, because the theory was that the victims had lied to. There was one of the victims' mom. It was the mom who there was perhaps an issue of custody. Your Honor, here again, the trial judge, who was the motion judge, found that trial counsel's behavior did not fall below that of a ordinary infallible attorney. And moreover, the motion judge also found that there was no prejudice. Here, trial counsel successfully defended 8 out of 15 charges. There were 2 required findings. There was a no pros on the morning of trial and 5 acquittals. That was a pretty good job. There were 15 very, very serious charges.
Let's talk about the judge's decision for a moment. The judge suggests that Dr. Block's testimony, although it's research-based, made intuitive sense. Doesn't that belie her allowing the expert to testify in the first place? If it's intuitive, to me, that's another word for it's common sense. And if it's common sense, why is it being admitted in the first place?
Well, Your Honor, the trial judge who heard the Commonwealth's motion that this expert could help in delayed disclosures, because this was a lengthy delay.
That's exactly why I'm going back to that's what Dr. Price would refute if she was called as a witness. The fact that there are delayed disclosures, these children are lying not because of their memory issues, but because they're lying. It would bolster the defense. The Commonwealth prosecutor in closing argument used Dr. Block's testimony, didn't she?
Yes, she did.
So it's important enough to mention an argument.
The prosecutor's argument was fairly long, was 35 minutes. She mentioned the expert 9 times. There were 35 pages of transcript. That was.
But if I'm remembering this correctly, didn't the prosecutor say something like, jury, view the evidence through the lens of Dr. So-and-so?
And I believe, I know she did say that. That may have been in reference to the one victim who was not able to go forward, who did not go forward with the MIT interview, the one who testified that he was there, but nothing ever happened. Gigi, I believe, was his name. And I know that the prosecutor used that language when she talked about the fact that Gigi did not testify that it had happened to him as well. I would suggest the trial judge, who was the motion judge, found that this testimony was peripheral. The decision of defense counsel to retain or to not retain an expert in the moment, in the temporal moment when prior to trial was not manifestly unreasonable, and I would suggest that is the framework under which that decision must be looked at.
Would you agree that Dr. Price's testimony would have been admissible at trial to refute Dr. Block's testimony?
Well, I don't know, and actually I believe it certainly would have been up to the trial judge to decide whether or not.
If you're not sure, isn't that exactly why there should be an evidentiary hearing?
Absolutely not, Your Honor. I would respectfully suggest that based on the trial judge, who was the motion judge, that he found it was peripheral, based on the fact that case law, the courts have said that the decision of whether to retain an expert falls squarely within a strategic decision, that it can't be looked at with hindsight. This was not manifestly unreasonable. The Commonwealth would ask that this court affirm the trial judge's order denying the defendant's motion for new trial. The Commonwealth would rest on its brief. Thank you.
All right. Thank you both. Thank you both for your able arguments. The case is submitted. We are going to take a 10 to 15-minute break and return then and pick up with the remaining 3 arguments on the list. All right, welcome back. All right, the next case, which I'm going to remind everybody, is fully impounded. So we must use synonyms, not synonyms, pseudonyms, pseudonyms or initials. But what I find most helpful is if people can just refer to everyone sort of by their status, like mother, father, child, things like that. That helps, I think that helps keep everything clear. All right, the next case is 2023P 0409, Department of Children and Families versus Mother. I understand there's a division of time on the other, on the appellee's side, and that it's going to be 10 minutes for counsel for DCF, is that correct? That's correct. And 5 minutes for counsel for the child. All right, thank you. And Attorney Chenevert?
Shenevert.
Shenevert, okay, I'm sorry, I mispronounced that. We're ready whenever you are.
All right, thank you. Good afternoon, Justice Wolohojian, D'Angelo, and Justice Milkey. Dana Shenevert on behalf of the mother. It's important to note the trajectory of this case and how it was so profoundly impacted by the onset of COVID-19, the COVID-19 pandemic. In October 2018, the goal had been changed from reunification to adoption. But in July 2019, the goal was changed back to reunification with a target date of November 2019. The light was so bright, the reunification process was going so well. Mother was engaged in therapy, she was working productively with DCF and the collaterals at CCFCS, and she was enjoying unsupervised visits for up to 5 hours with her daughter. And then COVID-19 came in December 2019 and stalled the reunification process. This was devastating to Mother, so yes, her mental health seemingly spiraled out of control, but only after the progress in the reunification came to a grinding halt. Now, the record reflects, and it is clear, and we concede, that she was struggling at that time. However, although her relationship with DCF was strained, she was always able to work collaboratively with the collaterals at CFCS, one of who testified at the trial to having seen observable positive changes in Mother's ability to think before she acted and to sort of engage better coping skills, be able to cope in healthier ways.
Those changes, though, that she observed, was that pre-COVID or post-COVID?
That was post-COVID, right? It was during, like I said, the goal was no longer reunification, and she was, working with Mother on her coping skills, home visits and in-home services.
When was the date that the goal was changed to reunification, and when was the date when it was changed after that?
So I don't know the exact date in October 2018 that it was changed to adoption, or the exact date in July 2019 when it was changed back to reunification, but I can submit a letter after.
And then, but after July 19th, when was it changed back to adoption?
Unfortunately, I do not have that committed to memory, but I'm happy to follow up with a letter to the court.
Okay, and maybe just a passage of time, but when are you dating the pandemic as starting?
Well, I guess I'd like this court to take judicial notice that we all started reacting to COVID-19 in December 2019. However, the courts everything shut down in March 2020.
The state of emergency wasn't until March 2020.
That's right. Right.
So as of that date, the goal had not been changed back to adoption?
That's correct.
And what was the status of things before then in terms of, had there been any incidents with the mother's dysregulated behavior or anything like that before March 2020?
Yes. Yes.
between July 2019 and March 2020.
The dysregulation seemed to be ongoing intermittently throughout the life of the case.
Right, that's what it looked like to me too. So maybe you can address that a little bit, because that seems to be the crux of the matter, which is that the mother has, for whatever reason, an unfortunate inability to control her actions within acceptable boundaries in a variety of different contexts.
Sure.
Over time.
Sure. I'd like to bring the court's attention to adoption of Yetta, where the father in that case had an angry tone. The trial court made findings as to the father's angry tone and his demeanor with some people, collaterals, DCF, and the like. But then that court found that demeanor, those unparental, what we would maybe deem to be unparental-like behaviors, are not necessarily supportive of a finding of a parental unfitness, because the children never experienced, or they never were fearful of father. There was no nexus between, that father's positioning with DCF and the collaterals and his relationship and his ability to parent the child. And so mother would liken this case to that one, where, yes, there was strain between her and DCF. She always collaboratively worked with CFCS, and there were other people that she had, some people that she had problems with. But the visits, they were always beneficial with her and the child. The child never feared for mother, or had a fear of mother. And mother's anger towards DCF did not impact her ability to provide the minimally acceptable care for this child.
But what do we do with the fact that her inability to control her temper, and just forget temper, conduct, such that she's assaulting and battering various people, including police officers, EMTs, puts her, causes her to be unavailable to parent her child, whether because she ends up being hospitalized for dysregulated behavior or because now she's subject to various criminal charges. I think that's the connection, not that she's directly displaying anger towards the child, but that her conduct leads to consequences that make her unavailable. How would you address that piece of it?
Sure. I'd have to say that those things are undeniable on this record. However, during the time when she was experiencing those things, lashing out at police officers, she did not have the child in her custody. So, it wasn't a situation where she had custody of the child, she went to jail, and then wasn't available to parent. She always had the support of the mother, her maternal grandmother, and her husband's, or the cousins, right? So they could be suitable caretakers for the child while she was able to, get herself together from the hospitalizations, the involuntary hospitalizations. But the behaviors, they did not take her away from the services that DCF offered vis-a-vis the visits, the parent-child visits. She was present for the visits. She engaged with the child with the visits. She was able to control her behavior in front of the child during the visits. Her behavior that you speak of, Justice Wolohojian, was always outside of the presence, mostly outside of the presence of the child. And that is the crux of Mother's argument today. There's no connection. I mean, there's, the speculation of how her behavior may in the future put the child at risk is not evidence of current parental unfitness. The record does not show that these behaviors took her away from her child, except for the one time when she was involuntarily hospitalized and maybe wasn't able to attend a visit. Otherwise, she was available to the child, and they had positive interactions during the visits, loving relationship with the child.
I take it that you're not arguing that there's any problem with the placement with the cousins?
That is a problem. That mother does object to that placement.
No,
Just-
I understand object to it, but there's no issue raised like it's an unsuitable placement. At least I didn't see anything in the record to show that.
Well, there is a position that that placement is inappropriate just because of the ongoing use of corporal punishment as discipline for this child.
Well,
this 5-year-old.
ongoing, I don't know. There wasn't record evidence of ongoing.
Well, there was, the record reflects that the foster family was warned in October 2019 that they should not be using physical discipline with this child. They were warned again the following year in, let me check my notes real quick. They were warned again in 2020 that this was not an appropriate use of discipline, or appropriate method of discipline for this child. I do know that the foster mother testified that, we've learned some lessons over the course of the case and we will never again do that, but they said that back in 2019 when they were warned against doing it and they did it again. So for that reason, and because of this child and her experiences, she should not be punished in that way. And so for that reason, mother does argue that it is not an appropriate placement for the child.
So if we were to conclude that the judge did not err in finding the mother unfit and did not err in finding that termination was in the child's best interest, where does that leave us? I didn't see that are you arguing that the judge, that there's some problem with DCF's permanency plan in those circumstances?
Selecting this placement for the child is problematic, especially when they are on notice that this family has been using this type of punishment on this child. Now, if I understand Your Honor's question, you said if you were to decide
that there was no error in concluding that the mother was unfit, and there's no error in concluding that termination is in the child's best interest, termination of parental rights. You still want us to, because I'm trying to figure out what the consequences are of your argument that that placement here would be inappropriate.
Yeah, that's tricky. I see.
Do you really want us to go down that road?
I don't think that mother does. If that is the reality, then, mother would prefer for the child to be with kin than be with strangers.
I appreciate your clarification on that front.
Sure. Thank you for asking.
It made sense to me.
Counsel, can I ask you something about what you said? In looking at the findings, there are findings that indicate that your client was incarcerated at various portions, sometimes on bail, sometimes for a probation surrender, and other things. Can't we take that into consideration in the fact of not just for her potential volatility or whatever, but also how that impacts the child in the future, that if she keeps running into these issues, she will be incarcerated at certain points? And how, you mentioned that there are relatives that can take care of the child, but isn't that something we should take into consideration?
This court would be in its discretion, yes, well within its discretion to consider that past behavior and actually, conclude that maybe that past behavior is prognostic. But we do have to look at current parental unfitness in this case. And mother did have open charges from that behavior that she engaged in prior, but they were not convictions, they were open cases. At the time of trial, mother had made great strides that the CFCS worker testified to. She had, maybe her responses during that time were not ideal, but they were better. She was making progress towards, being able to be a positive sort of be able to be a positive parent, present for this child. Oops. Sorry, I lost my place. I guess I'm running out of time, but I do want the court to take note that, the standard for unfitness is not whether the parent is the perfect parent, let alone an ideal parent, maybe not even a great parent, but it's grievous shortcomings that put a child at great hazard to where basically she can't safely parent this child. And that is simply not the case here. Mother demonstrated that she could care for the child, she could meet the child's needs. The child and mother have a bond. Termination wasn't, while it's not necessarily an abuse of discretion by definition, was not necessary in this case to achieve permanency for this child because of the familial relationship. They're going to keep running into each other at family events. The visits and things will happen. So mother would ask that this court look to that and say, okay, termination may have not been necessary in this case.
Accepting that as true for the sake of argument, how can we, as an appellate court, do anything about it if it's not an abuse of discretion?
That's a great question, Justice Milkey. I know that the standard here is error of law or abuse of discretion. And Mom would just like for you to take a look at the case and see if, by chance, you could find that there's a way to keep the legal relationship intact.
Attorney Schoenevert, the one thing I would add to your summation about what unfitness is not is that unfitness is not a reflection of lack of love between the mother and the child. We know that and we recognize it.
Yes, it goes without saying, and thank you for that. If the panel has no further questions for me, I would rest on the brief.
Thank you. Let me just check. No questions. Thank you. Is it Attorney Seventer who's going to argue first?
Van Seventer, yes.
Oh, Van Seventer. I'm so sorry.
Good morning. May it please the court, my name is Henry Van Seventer, and I represent the Department of Children and Families in this matter. The department requests that the panel uphold the trial court's decision in all respects. No termination case is a happy one, and this is no exception. But the record before us is clear. Mother's behaviors, which often manifests in episodes of uncontrollable aggression and violence, make her an unfit parent. Exposure to these behaviors and mother's resulting absenteeism due to incarceration or hospital long ago when mother was a child is not temporary.
Could you address the arguments about COVID and how it impacted this case?
Yes. I think COVID should be seen as, COVID affected all of us, and it was a trial, but especially for mother. But as we've seen mother's pattern of behavior, when she comes across, when something happens that affects her negatively or creates some kind of obstacle, she doesn't react well to it. I think some of the evidence that came into the record as a result of COVID should be seen as that. It should be seen as, well, how does she react when things are not going her way? And she did not react well. One of the things that was going on during COVID was she was having meetings with the first team, which DCF, when the plan was still reunification, which they put into her home. And the plan there was there to help the transition for the child back into mother's care. Well, mother did not engage with first. Mother missed first appointments. She said, I think in her testimony, that they sounded like her mother, and she was unwilling to work with them. And eventually, even the first the first services, which were there to help her and to help child reunify, were ended due to her lack of engagement. And then several months later, I believe in the fall of 2020, her social worker, Ms. Clark, asked her and tried to push to get First Team back into the home to try to push for reunification again, and she refused the service.
You would agree, to echo opposing counsel's viewpoint, that there's nothing in the record to suggest that when she was with the child, she ever did anything dangerous, concerning when she was actually with the child. Is that fair?
Well, I think there were incidents of police intervention and hospitalizations while the child was quite young, before it was committed into DCF custody. But the department does, it is a sad case because the department is aware that, and Judge King made findings that when during visitations, mother is quite caring and loving for the child. But those can't be taken in isolation. The pattern of behavior, whether her outbursts are directed towards the child or not, child will inevitably be exposed to these outbursts. There was, and these are the recent examples, even a few months before trial started, in early 2021, there was an incident with some driving infractions. Typical day-to-day things that, if child were with mother, would likely be exposed to. And that incident resulted in a Section 12 where mother had to be put into, a 4-point restraint. Her efforts to kick and bite and even spit on the police and ambulance personnel, child would be exposed to that. She would see mother being put into a spit mask and things like that, of that nature. And even if that abuse is not directed towards the child, there is case law to say that just witnessing such behaviors is dangerous to the child's well-being.
Do you have anything further you wish to add?
The only other thing I would wish to add is that child is healthy and thriving in her adoptive home with the family she identifies as her own. She deserves to find permanency as an adoptive member of her chosen family, and the trial court's order should be upheld in its entirety.
All right, I don't see any further questions. Thank you. We have your brief.
Thank you.
Attorney Appleyard.
Sorry. May it please the court, my name is Jennifer Appleyard, and I represent the child in this matter. I first wanted to inform the court that as I was preparing for oral argument, I found a typo in my brief on page 15. I mistyped the date. It says 2017 at the top, and it's supposed to be 2021. I cited it later as the proper date on page 44, so I apologize. Since the filing of the CMP in 2018, mothers had a number of opportunities to reunite with the child, and unfortunately, it has not been successful. In August 2019, the goal was reunification, and that goal changed in December 2020. The goal changed to adoption. I would suggest to the court that it's in the best interest of the child to be adopted. The evidence presented at trial is that she is in a loving and stable home where she is happy and has been thriving since June of 2019. She lives with relatives who the mother suggested, and she refers to them as family. She has done well in school. Her medical and dental needs are all up to date. She has a diagnosis of sickle cell anemia, which she is treated for, and she takes a medication daily. The pre-adoptive family was approved by DCF, and I would suggest that it's in her best interest to be adopted by them, and she deserves the permanency. And this is why the court should affirm the lower court's judgment.
What's the visitation situation going to be going forward?
So the pre-adoptive family is in agreement to supervise the visitation. I know I'm going to go outside of the record if the court would like. It's my understanding there is a visit scheduled for December, and there had been a visit scheduled in the past few months.
So visitation is going to be at the discretion of the adoptive parents?
I believe the findings specifically state
I believe it said twice a year.
I think that's correct.
Okay.
And then there was also letters and gifts that were included in that order.
Okay.
But there's nothing prohibiting more frequent visits if it's in the judgment of the pre-adoptive family, correct?
My understanding is it rests in the discretion of the pre-adoptive family. Yes. As argued here today, and for the reasons set forth in my brief, I ask the court to grant the child the permanency she's asking for and to uphold the findings and allow the petition to dispense with consent for adoption.
Questions? I don't see any questions. Thank you all for your argument. And the case is submitted. We appreciate the argument that all counsel have made. Okay, just going to let, a lot of movement going on. I'm just going to let people. Okay. The next case is 2023 P0183, Joel Weiss versus Lumis Sales. I understand that it's Attorney Bucking who's going to be arguing, but not first. It's going to be Attorney Churchill.
Yes.
I was focused on the fact that there had been a change on the slip. So we are ready whenever you are, Attorney Churchill.
Thank you. Good morning, and may it please the court. At trial, Mr. Weiss was required to prove something incorrectly that he could not prove, which is that he created, or that his corporation, JOSL, a single-person S corporation, and Eliason, a long-established staffing company, were created for purposes of Loomis's misclassification of him. And that was set out in the jury verdict slip, which required him to show that
Can I stop you there?
Yes.
The premise of your argument is that the judge chose the created and maintained version of the proposed verdict slip over your created or used or created or maintained. As you conceded at trial, there wasn't much of a difference between used and maintained. Isn't that premise only half correct? Because if you look at the wording of the final jury verdict slip, the standing portion is in two pieces. There's the question, and then there are the answers. The question, and I'm looking at it on my iPad, it says created and maintained. The judge made that substitution. The answer says created or used.
Yes, I'm aware of that inconsistency,
Okay,
Your
it's
Honor.
because neither of you addressed this in your briefs, as best I could tell.
Yeah, and I think the reason for that is it doesn't change what would have happened in terms of the wording. So a reasonable jury looking at the question before it ever got to the answer is going to be analyzing the question. It's not, I think it's reasonable to infer that that's most likely what happened, is a jury's going to look at that question. They're going to look at the first part, were these legitimate businesses, or were they created or maintained? So
why isn't it equally reasonable to infer that when the jury is asked to put its X or check by the right line, they're focusing on the language that is in the answer to that?
I think the answer, Your Honor, is that the standard is not whether they might not have been misled, but whether they might have been misled. So if the court agrees that the language in that question was an error of law, then the question becomes, might it have been different if that error of law had not occurred?
So I have a couple of questions. The first is, this is not the actual verdict slip that was returned. Normally, I would expect to see that, the one with the answers from the jury. So I don't know if it's unavailable or why it's not included in the record, but I suppose we're just going to accept that this blank one is the one that was actually given to the jury?
Yes, I would say, Your Honor, two things. One is all parties agreed that that was the form of the final verdict slip.
The
And also-
second thing is that, is this the document that was shown to the parties? I want to pull up the trial reference. And these iPads are great until you try to go find the actual page. But it's when the judge asks, is there any objection to the verdict form, which is right before it's given to the jury, both sides say, no, it's fine. And then when the jury comes back with its verdict, I didn't see any objection or a suggestion that there was ambiguity in the form of the verdict slip or that the jury would have been confused by the jury slip as it was given to them. So assuming that I'm accurate in that procedural recitation, how is your first issue on appeal not waived?
Well, Your Honor, when we were on the morning of day 6 and the court presented a revised version of the verdict slip, there was an objection from Lumis and the court revised it. I objected to the revised version and the judge said, that's my decision, it's done. When the clerk, in the same way that the clerk comes and says, do you agree that these are the exhibits and that this is the verdict form, that's a ministerial question about whether—
It wasn't a question in ministerial, I believe, and that's why I wanted to find the actual question, and maybe you can help me, but I believe the judge said, here's the form, does either of you have an objection?
That was a question from the clerk.
Was it?
Yes.
What page
to my
was that?
memory. In the same way that the clerk asks, are there any objections to the exhibits? Like, we all look at the exhibits, we all agree that they are what they are. Same thing with the verdict slip. It was not an opportunity to relitigate what the court had already decided.
All right, well, I guess we can check to see if it was,
And I think just to underscore
and
that—
then when they come back with their verdict, you don't raise an ambiguity or inconsistency in the verdict form.
Because, Your Honor, I had already objected—
No, I'm not asking you for your reasoning, or the reason why you didn't. Right, it's correct, you did not.
That's correct.
So normally that's required.
I don't agree with that, Your Honor, that
Okay.
if the form of a verdict slip has been objected to, and it wasn't that it was inconsistent when they came back. It was that the wording
Neither
of it.
side pointed out to the judge that it was inconsistent.
I'm sorry?
Neither side pointed out to the judge that it was actually inconsistent with what he said he was going to do.
Well, the wording of the...
She, sorry.
Yeah, the wording of the question was exactly what she said she was going to do. That answer where it said no, created or used, actually Loomis did point that out after it had gone to the jury. After it had gone to the jury, I think it was the next day, but it was too late at that point because the jury already had begun deliberating.
What was your position when Loomis objected to the inconsistency?
That it was too late because the jury had already begun deliberating.
So it kind of invited error?
No, because again, the only inconsistency here is that answer where it said no, created or used. There's no reason a jury would have had to go and look at how the no answer was phrased if they were already answering the question itself. They answered yes. There's no reason to believe that they looked down to see how the wording of the no answer was phrased. And the challenge was not to the answers. The challenge was to the question itself and how it was phrased. And that clearly, we objected vociferously on day 5, and when we had the charge conference and we looked at the initial draft. And then I objected again on the morning of day 6 when the court said that the form of the question was going to change.
Your proposed, I think it was more to the instruction as opposed to the verdict slip, didn't really comport with Chambers either, did it?
Well, I think it did, Your Honor. The overarching point here is that if you look at cases from DiPiante all the way to the present, the SJC has recognized that the touchstone of the question of standing is flexibility. That if you have a bright line rule, employers are going to seize on that and they'll be able to do an end run around the statute. So the whole advantage of using the term or as opposed to and is it incorporates that flexibility. If it was created for purposes of misclassification, then that's evidence that there was an end run. If it was used for purposes of misclassification, then that's an end run. So the significance in what we were proposing with the or is to recognize that flexibility. The problem with the and is it imposes a bright line rule that we had to show that those companies were created for purposes of misclassification, which this court already had said was not required. And we could not have won this case. There's no way, given how that question was phrased, that we could have won that first question.
But see, that seems to me like a little bit of a weird form of reasoning. If the instruction is correct, it doesn't matter that you couldn't win, right? If the instruction was correct. Perhaps under the law, if it's correctly explained, you just couldn't win. But, so I don't think you can, do you see what I'm saying?
Well, so,
at first,
yes.
you'd have to establish that the instruction was incorrect as a matter of law. Not that your facts, not that, it doesn't seem to me that arguing that your facts couldn't meet a correct recitation of the law is a basis for reversal.
No, that's not what I'm sorry, Your Honor. If
Okay.
That's what you heard me saying. That's not what I meant to say. What I meant to say is the way the wording of question 1 ended up, a jury could not have answered that question of fact, independent of the way the instructions were. A jury could not have answered that question in our favor because they had to find that.
But if it's correct, why does that matter? If it's a correct legal statement, why does it matter that you couldn't meet that test?
Well, our argument is that it's not a correct. It was an erroneous statement.
That seems to me like a different, that seems to me like a different argument.
Right. What I'm arguing is that the statement of law in that question was incorrect. It was inconsistent with this court's prior ruling. It was inconsistent with DiPiante and all the cases that came after it. That's what I'm arguing, is that the wording of it was incorrect. And the jury had to have returned an answer in that question in Loomis's favor because of the way it was phrased.
That seems to me more like an argument about prejudice rather
It's-
than an argument about whether or not the question was in error.
It's both, because I have to show prejudice as well. I think the statement of it was erroneous as a matter of law, and it was prejudicial because there's no way we could have won that question. And the court recognized the significance of the wording of that question because I had proposed initially just a generic, did Joel Weiss have standing? Because I agree, standing is complex. The law is kind of in flux, and basically you have to look at all these different factors. So it doesn't lend itself to an easy statement. And the court said, no, I don't think the jury understands standing, even if we explain it to them, so we have to give them a question of fact. The problem is if you try to reduce it to a simple question of fact, there's a risk, which manifested here, that it's going to be wrong.
But the second part of question 1 is in the alternative.
Right.
So, if the jury looked at the first part of question 1 without reaching the alternative and said this was a legitimate business-to-business arrangement, then which the facts could show, frankly. So,
right.
So where do you get your prejudice?
So that could have happened, but the standard is whether it might have been different. And so we have to imagine a possibility that the jury looked at this question and said, what does legitimate mean? Well, let's look at the next part of the question. Well, we know he can't prove that second part. It's like if I say it has to be A or B, and I know it can't be B, then it has to be A. That could have been the way the jury looked at it, and that would have been a very logical way to analyze the question. So I can see...
And the parties and the judge had the opportunity to remove the inconsistency on day 7 when someone overnight noticed it, and you objected strenuously and said no, presumably because you liked this language in the answer part, and you said it's too late. And the judge said, okay, it's too late.
Well, actually, what happened is...
I'm looking at the transcript.
Right. And the court agreed that it was too late. And I think it's a matter of law. Once a question has gone to a jury like that, it is improper to stop the proceedings and bring them back. We don't know what they had been...
Fine. If there's a perceived error by all parties, and they all agree it's an error, what is wrong with bringing the jury back and re-instructing them? We gave you an incorrect jury verdict slip. We're giving you a new one. What case do you have says that is improper?
But I think the point here, Your Honor, is that the language in the no answer, where it said created or used, if that had changed, that wouldn't have helped us. It would have hurt us.
Well, so you made a strategic decision not to bring them back, even though you saw that the verdict slip was in essence inconsistent with.
But yes, because it would not have fixed the error. The error was in the wording of the question, not in the wording of the answers. If the court had, said you're going to bring it back and change the question, then that would have been something to my client's benefit. But that's where the error was, in the question, not in the answer. Ultimately here, the way it was finally worded, the question, was contrary to this court's prior ruling. It's contrary to what the SJC has said about the flexibility of the standing question. And I think it's important to note here that the jury ultimately found that Mr. Weiss was misclassified. And so the standing issue is significant. And the wording of this question meant that there was no way he could have won, even though this court already had ruled previously that it could have. And for whatever reason, the Superior Court was very dismissive of the prior decision and felt that they weren't bound by it as a matter of law.
Now, at the end of day 6, you're correct. It was the clerk who asked the question, is the defendant satisfied with the verdict slip? Is the plaintiff satisfied? Both of you said, yes, we are. Acknowledging that it was the clerk and not the judge, why isn't that enough?
Because, Your Honor, the way I understood that, and the way I've always understood that, is the same thing with exhibits. There may be exhibits in the record that I have objected to, and if I say, yes, I agreed these are the exhibits, that doesn't mean that I'm waiving my prior objections to those exhibits. That's the way I understood the clerk's question. Is the form of this what the judge said it was going to be? And I was saying, yes, that's the form.
At what point did you notice the inconsistency in the verdict slip?
When Loomis brought it to the attention of the court, after it had gone to the jury.
And understanding that time has expired, I just have a question or two on the jury instruction piece of this. Am I correct that on appeal, the only parts to the jury instructions that you're objecting to were the examples of non-exclusive factors that the jury could consider?
Yes, and just to put that argument into context, that is really a subsidiary argument to the first one, and it just underscores the way I think the standing question has to be understood is you look at all the circumstances. That's what the SJC said in the Patel case. It's a case-by-case determination. And so when the court tried to take those particular factors and craft them in a certain way, it works against that general idea that a jury should look at all of the factors in a particular case. You know, I disagreed with the way that she characterized them, and I think they were incorrect. But the bigger point is that I think the court was looking at this in too black and white of a manner, that the jury should have been instructed and should have had a question that allowed them to look at all the evidence in a case-by-case basis, not through some bright line test.
All right, thank you. We have your argument.
Thank you, Your Honor.
Attorney Bucking.
Thank you, Your Honor. Good morning, members of the panel. May it please the court. I think we have to focus not just on what the judge said in the verdict slip, but what Mr. Weiss suggested that she say instead, and what case support we have for either of those. We said created and maintained. They said created or maintained, okay? And so we...
Can we start with why your brief does not say anything about the inconsistency in the verdict slip? Seems pretty important background fact.
So, Your Honor, we don't think it's that significant. And if I
Why? Because you won, or?
No. Sure, it's possible that it could have had the effect that the panel has suggested in questions. But what I think the primary reason is because even though created and maintained is clearly correct, and I'll explain the reason for that in a moment, even that doesn't really matter. And I think that the issue, we should look at the verdict form and look at the question that was asked. It was in two parts, okay? And the first part of the question is, did Joel Weiss provide services to Loomis through legitimate business-to-business relationships? And the answer that was checked was yes, legitimate business relationships, okay? So whatever is in the second part of the question, whatever in the or, we don't know whether the jury reached that or not. But the jury...
Isn't that where the jury put its mark on the form?
No, the jury put its mark under yes, legitimate business relationships.
No, but the point is in the answer portion, not in the question portion.
Right, but it's a two-part question. Were there legitimate business relationships? Answer, yes, they were legitimate business relationships. Or this other thing, and as Mr. Churchill said in his remarks, the jury might not even have looked at the second answer. That's true. I submit they might not have looked at the second part of the question. The first part of the question asked something, and they clearly understood it, and they checked the box. Yes, legitimate business relationships. So I think the most important thing in the verdict form is that. You can ignore the rest of it because they said, yes, these are legitimate business relationships. Not just in the context...
Aren't the answers... Don't they make sense only if these answers are mutually exclusive?
I'm not sure of that, Your Honor. I'm not sure that that's how it was framed or that that's how it necessarily has to be. I would say that you should look at the answers in the context of the question, particularly the part of the question that corresponds with the answer, and you should also look at them in the context of the jury instructions that gave very detailed explanations of all this.
Why doesn't it help your client if the jury could have understood this as a disjunctive?
Your Honor, I guess I have a hard time with this because we're taking that standard out of thin air. So Mr. Weiss says it should be created or maintained. We have the Attorney General guidance that the SJC said in Chambers is entitled to substantial deference, saying created and maintained.
You're correct, that all the cases that address this say created and maintained. But tell me if I'm wrong, none of those cases dealt with the fact pattern here where at least one of the corporations, where the corporations existed prior to the dealings between Mr. Weiss and your client, but arguably were used as an end around the statutory protections.
That may be true that the cases that the SJC has heard, I think that may be correct. Certainly,
Right, it can't, you'd have to read that statement, created and maintained, in the context in which it was stated. None of those cases involved a situation where let's say, arguably the purpose of a corporation changed midstream. And so, unless you have a similar factual basis in those cases, then the statement created and maintained really, I don't think can be read as far as you'd like it to be read. It seems to me perfectly conceivable that there would be standing if a corporation began with a legitimate purpose, a legitimate non-wage act avoiding purpose, and then, you know, in the course of things, perhaps years later, was then used for an illegitimate purpose. And I don't think the statute or the cases or the AG's statement would require that be blessed.
So, Your Honor, I'd say a couple things to that. First of all, if the facts of this case in any way resembled what you just described, then maybe there would be some additional guidance that the court could give. And so I don't know, that's a different case. But I would submit that, in fact, the Attorney General guidance deals exactly with this case. The Attorney General guidance gives a scenario. It says if a painting company can't finish a painting job and hires another painting company, presumably a painting company that already existed, then that's okay. And the only time you have a problem, the only time, is when the other company is created and maintained to evade the law. That term is used consistently. The AG guidance has been around for 15 years now. There's never been any suggestion to the contrary. And if there was going to be another standard, I can guarantee you what it would not be. It would not be created or maintained. You wouldn't change one of the three words in the applicable standard. You might say other things. You might restate it in a different way. You wouldn't change one of the three words. That's impossible. There's no way the SJC would say, we've now said created and maintained 4 different times. We affirm an AG guidance that we say is entitled to substantial deference. We've used this same term every single time. And now the judge committed clear error by using those same 3 words? That's impossible.
But how do you deal with the fact that in the jury instructions, not the slip, in the jury instructions here, it talks about used. It talks about compelling someone to use a contract. It is, frankly, more consistent with Mr. Weiss's version of the created and maintained issue than the verdict slip.
Well, Your Honor, I'm not sure I should agree to that or not agree to that, because if that were the case, I think it would help me. But I think actually nothing in those jury instructions says used. There are other phrases that are used that might have an ameliorative impact on the verdict slip if you think there's something wrong with the verdict slip, because it gives a holistic summary of the various cases. But I submit to you that all of those cases, if you really look at them, whenever they talk about the use of a structure, they're talking about the use of a sham structure that is created to evade the wage law. They're not saying use some legitimate business, use some other entity. That's just not what they're saying. They're always talking about...
Isn't the question that is posed in Chambers, or the issue in Chambers is whether the worker's use of the corporate form was at the worker's behest or forced upon the worker by the employer in order to misclassify him. That's at page 109. That's the question that the jury has to decide, isn't it?
Well, I don't...
I mean, that's
In
right
a
from
manner of-
Chambers. I just read it right from Chambers.
In a manner of speaking, Your Honor, yes, of course, that is another way to phrase it. However, that question cannot possibly mean that the determining factor is whether or not the company who's using the services at issue wants to subcontract, because then it would be no test at all. 100% of the time, that's the case in every subcontracting scenario. So an example I've used with the previous panel, the Celtics use Aramark to sell beer and hot dogs. They don't do it themselves. You don't say, oh, are they using them to evade the law? You ask, is that a real
Question for the
company?
jurors to decide what's the intent, isn't it?
No, I don't think so. I don't think so, Your Honor.
Is it forced upon the worker by the employer in order to misclassify him?
Right.
That's an intent. Why is the employer doing it? If it's in order to misclassify him, it's a violation. If it's for another reason, like you just said at the TD Garden, it's not in order to misclassify him.
Maybe, Your Honor. However, okay, that we're talking about is the creation of a sham corporate structure or the creation of a sham franchising structure like in DP Ante. That's the it. So
I think
that's how you decide.
To me, in Chambers, something that struck me was the court interpreting the Attorney General guidance. And it said the Attorney General articulated certain factors material to a determination whether the corporate form represents a legitimate business-to-business relationship. That's looking to the relationship, not to the technicalities of corporate formation, or one whose raison d'etre is to prevent the classification of workers as employees. It doesn't seem to me that the court is seeing created and maintained as some kind of talisman of the legal test.
I think it is, Your Honor. That's what raison d'etre means. It means reason for being, right? It's a French term that means reason for being. Why does the corporation exist? By the way, that's the word the AG used, exist. And in each of the SJC...
But it says that in terms of a relationship, and I think that's, well, I mean, that's what they say.
It's not what, respectfully, Your Honor, I don't think that's what they say.
All right,
Each
so
of those
assume
cases,
that we were to conclude that. What then? Where does your argument go then?
the standard that is consistently established is the only time you disregard the corporate form is alter ego, which is raised in the DP anti-dissent and affirmed in Jinx, joint employment, which came up in Jinx, or third, the issue in this case, when a corporation is set up to evade the wage law. That's the term the SJC uses, set up. In DP Ante, it was set up because the company created a sham franchising structure. In Chambers, it was set up because the company said you can't drive for us unless you form your own company. In the AG guidance, they used the term exist. It existed in order to avoid the wage law. Everything else is subcontracting. Unless you want to shut down law firms and accounting firms and consulting firms and every other business-to-business arrangement in this Commonwealth, this can't be the test. It's a jury question. Anytime you don't directly employ somebody and you use another business, we're just going to say, oh, the jury gets to decide what was in your mind, what was your intent. That's not what this says. It says you look at whether it was set up for that reason. That's the law. So all these other words that you're pulling from the cases, they're all in those cases, but they're all in those cases as supplements to the primary issue, which is has the company been created?
Here's a direct quote from the jury instructions that the judge gave in this case. An employer may not insulate itself from liability for misclassification by causing or creating another entity to contract with its employees, nor may an employer use contractual arrangements with third parties as an end run around the statute. Is that a correct statement of the law?
Yes. So then I misremembered that the word use appears, but Your Honor, I submit to you that the
Is that a correct statement of the law?
Yeah, it comes. I think that's word for word from one of the cases, but it's part of a body of law that clarifies what that means. It means when the employer sets up a phony franchising structure like in DP Ante, or insists that a truck driver, go out and form a phony corporation in order to drive a truck like there was in Chambers. That's what that means. You just can't, if you just say, oh, let's look at those words and think of something else it might mean, and I would submit that the trial judge did the right thing in this case. She looked at the facts of this case. She, in the jury instructions, gave a bunch of citations from the law, including the prior panel's decision in this case, and said, look, consider all this stuff, but fundamentally the question needs to be answered is it a legitimate business-to-business arrangement, or alternatively, is this some sort of sham that was concocted? Can I raise one other issue, because I see I'm short on time?
Before you get to that,
Yeah.
You argued that with respect to the verdict slip, the jury would have just looked at the first part of the question and not had to reach the second part. The judge's instruction on page 1803 of the appendix says, if a business is created and maintained in order to avoid the misclassification law and to avoid its protections for employees, then it is not a legitimate business. That instruction seems to me to tie the second part of the question, question one, to the first part of question one. In other words, to say, you know, you have to answer the second part in order to know the answer to the first part. So that's the judge's instruction. So I'm wondering how then we can reconcile your argument about question one being sort of two severable parts, and so we don't need to look about whether the second part is inconsistent between the question and the answer, and or whether even and is an error because the first part just sort of stands alone. How do we deal with that?
Yeah, Your Honor, so I think I didn't mean to say it that broadly. What I would say is that the jury instructions, all of which are correct, that statement you just read comes straight out of one of the cases too, help explain to the jury what the law is. And the two-part question does too, and I submit that created and maintained is clearly correct. I'm just saying that that
You
second
would agree
part,
that the second part is connected to the first part?
unquestionably, it's the converse. The second, what comes after the or is the converse of what comes before the or, unquestionably. But what we should look at is what the jury said yes to, because the question here is, should we disturb what a jury does, right? This case was filed in January of 2014, 10 years ago next month. We've tried the case twice. Lumis has won twice. We're now back again, and the question is, should we disturb this jury's verdict because the judge used word for word what the SJC said and what the Attorney General said? I say no. But can I address one more issue? And I know my time is up, but I just want to address this issue of impossibility. Not only was it possible for Mr. Weiss to argue his case under the created and maintained, he actually did argue his case under created and maintained. And I would ask you to look at the appendix.
Okay, we're going to have to leave. Do you have a question?
I have a question.
Yeah.
Can I give you the site?
Go ahead.
1759. Take a
Okay.
look at 1759. He argued a version because if you look at the wording, it's in the passive voice. It does not ask if Loomis created. It's was it created? And Mr. Weiss's consistent argument in this case is, yes, it was, because in this industry you had to do this to work. And that's what he argued in his closing. Simply not correct.
Okay, your
that it
time
wasn't
has
possible.
expired, so unless there are questions, we're going to have to leave it there.
Yes, thank you.
I do have a question, and that is, it was uncontested throughout here that your client, Loomis, did not create either Eliason or S. Joel. That was still uncontested when the earlier panel saw the first case. Your argument was you prevail as a matter of law on this issue because this was not created. The panel disagreed with that. Why isn't that already resolved?
Because I don't think the panel said anything about the standard that would be applied. What the panel said was the standard on a directed verdict for us was if you look anywhere in the record, behind any crevice you can look, you find any piece of evidence that could be interpreted in a way favorable to them, they get a jury.
There was no evidence, tell me if I'm wrong, that Loomis created either Sojo, whatever it is.
Or Eliason. Right, but again, that was never the formulation. It wasn't whether Loomis created them, it's whether they were created. And Weiss's argument, the entire case, is that these companies, Eliason, K-Force, Joe Saul, They exist to avoid the wage law. They exist so financial services companies don't have to employ their own people. That has always been their argument. That was their argument in this case. It's their argument in their closing. And so in the prior appeal, the question wasn't, did Loomis create them? It's, were they created? That's their argument. And on a directed verdict standard, the prior panel said, I think you should be able to go to a jury on that. And they did, and they argued it in their closing.
Any questions? Any more questions, Jim? No, thank you very much. All right, the case is submitted. Thank you both for your arguments. It's a very interesting case, and we appreciate your arguments and the briefs.
Thank you.
I'm just going to wait so that you're not disturbed. Just let the dust settle. All right. Our final case this morning, and I'm just going to remind everyone that it's partially impounded. So at this point I can't remember, but I assume it's names. Is 2023P0200 RW versus M.T.G. And is it Attorney Levine Pirro?
That's correct, Your Honor.
Okay.
Thank you. Good day, Your Honors. May it please the Court, my name is Melissa Levine Pirro, and I represent the appellant RW. This case comes in front of you after the lower court vacated an extension of an abuse prevention order under Mass General Laws, Chapter 209A. The original ex parte extension order was obtained on November 1st, 2022, and the extension hearing was held on November 16th, 2022. And after hearing from respective counsel for both parties and testimony from both parties, the court decided to vacate the extension of the abuse prevention order. It's our position, as I'm sure you are aware from reading everything we have submitted, that the vacating of the abuse prevention order was an error of law and—
It was just on a technicality, but the ex parte order was going to expire of its own accord, because that's what ex parte orders do. This was the first hearing after notice, correct?
That is correct, Your Honor.
So it's not so much should we extend the order, it's should we issue the order?
Correct. And I use the term vacated only because that's what was contained in the record by the judge and the terminology that he used. So yes, it was whether or not—
Technically, it was a decision not to extend the order.
Not to extend the order, correct. So that the whole order did in fact vacate as if it had never happened.
Counsel, can I ask you, in your brief, and
Sure.
I'm not saying the facts aren't accurate regarding the allegations, you allege that there was physical violence that occurred a few years before the hearing and relationship. That the defendant who testified did not admit that. He did not admit that. So what standard do we have as to what the facts are that the judge found?
Sure. I mean, I think the judge relied on Amelie and the totality of the circumstances argument as to what happened during the parties' relationship. And he did state on the record that he thought that our client, RW, that her statements were credible and that she testified credibly as to the abuse in the past. He stated specifically that the incident she testified to with the appellee breaking her cell phone in front of her so she couldn't call a ride was inexcusable and basically amounted to criminal activity. And he believed that the rest—
So you're saying that the words that the judge said—
Yes.
We should take those as official findings of fact?
I mean, he is the trier of facts, and he was the one giving credence to the testimony in front of him that day. And it was never directly disputed from my memory by the defendant at that time that it did not occur. And he did perjure himself in other ways on the testimony as well. I don't believe he was the most credible witness to begin with. He did admit so much that he was drunk when he sent these threats through Instagram. He testified as to the time they happened, which was at night, and then on cross-examination stated they did not actually happen at night. It was the middle of the day, and that he texted her through Instagram repeatedly, and that he called her 11 times in a 20-minute period. I think...
Assume we were to agree with you that the judge made some sort of legal error. In the end, the decision, that could be one issue. But in the end, whether to extend an abuse protection order is very fact-dependent, right? And we cannot make factual determinations in the first instance here. And the judge made comments on the record about the facts, including, as you pointed out, a credibility determination. But obviously declined to extend the order nonetheless. So even were we to find a legal error, how does that, what relief would you actually be entitled to? Perhaps a remand for the judge? Because I was confused in your brief. You asked that we overturn the judge's decision to vacate the abuse prevention order. First of all, it wasn't technically an order to vacate anything.
Right.
But secondly, we couldn't really do, we can't make the contrary factual findings.
Right. Right. I think remanding to the lower court with instructions. And I think that there's more that this court could do so that the hearing happens again and she has an opportunity to present her case and why it does meet the legal standard, which I am happy to talk about. And I think also this court has the power to have broader implications on future restraining orders, because I think situations like this do happen a lot.
Like what? How are you defining situations like this?
Where a plaintiff in a restraining order hearing meets the legal standard for the restraining order based on their testimony and the credibility that the judge gives to their testimony, and then chooses not to extend or vacate a restraining order based on other extrinsic factors. So in this particular case, I think what the judge repeatedly says is that he believes that the defendant has learned his lesson. He's not one to determine that, nor is that the standard that an abuse prevention order under 209A sets out to establish. Since 209A's inception, it's designed to protect victims from abuse or threats of abuse from people in familial or dating relationships. And I think objectively, I know I'm biased as the person arguing that, if you read the transcript, RW meets that standard.
Counsel, can I, as a follow-up to Judge Wolohojian, you say remand. I'm not sure what we're remanding it for, because I think when we remand or reverse, we try to put the plaintiff back into the position, in this case, she would have been at the time of the error. But if we do that, this order that was denied would have already expired. It would have expired in, I think my date was November 16th, 2023. So what are we remanding it for? A whole new hearing? Or for what?
I think we'd have to have a whole new hearing, Your Honor. I think
under the same facts, so the plaintiff can't add any facts.
Correct, because her fear is still there. My client sits before the court today. She has PTSD from this abuse. She has a service dog that was assigned to her from the abuse, and I know that's not for your consideration today, but her fear isn't going away. These parties live in geographical proximity to each other, and she avoids going to huge areas just in the fear of running into this person. And as the lower court judge said on the record, her fear is palpable. He could see it in her face. He could hear it in her testimony. She met the standard for having reasonable fear. The judge also commented that the threats that were made were construed as threats. And he makes some comments as to the imminence of those threats.
Well, he said, to be fair, he said they could be conceived as threats. Now, I know the way you want us to read it, and again, I'm not saying that's not potentially a fair reading, but couldn't the judge also have believed that that threat was not objectively reasonable? Because he doesn't say that. He says, I understand why she could think it's a threat, and I can understand that, but there's another component to whether the threat. It's not just objective, it's subjective as well.
That is true.
So how do we know that he didn't find it subjectively not a threat?
And I think he has guidance from past cases and restraining orders that have already been established by this court and the SJC, and I think the context of those threats. So there hadn't been any contact between the parties in a year and a half when she got these messages. So we can rely on other things in terms of what a threat is. So the case PRVAI, which came before this court, was about a husband and wife who were divorced, and the last restraining order had lapsed that the wife had taken out against the husband. In the past, the husband had threatened her life, had been physically abusive, but they hadn't had contact in a matter of months, and there was no longer an abuse prevention order that was in effect. Out of the blue, the wife in that case, or ex-wife at the time, had received a text message that said, "Hi, Paula." It was a triggering event. That's how we classified it in the case. And she went back and sought a restraining order, which was granted, which was then appealed. And the court upheld it, saying the triggering event was enough for her to construe a message saying, "Hi, Paula," as being a threat. I think we can distinguish the messages that my client received in this case as being even more threatening in their significance. The text specifically said, "I will be at your home, and if you're home in 15, I hope your dad's there. Don't play games with me." And then, quote, "I will absolutely dismantle anything and everything. Does that make sense? Are you registering what I'm saying?" End quote.
You're saying, if I can paraphrase, that the threat here was overt.
It was very overt, and they live 15 minutes apart. So in her mind, to her, that meant he was in his car and heading over. And she wasn't home at the time. The reason this ended up in Framingham District Court is because when she called 911, which was her response, was to call local police and 911, the 911 operator advised her to go get an abuse prevention order and go to the nearest court. And when she looked it up, that brought her to Framingham District Court. But she was afraid, given the totality of the circumstances, the past abuse, that this was going to happen. She testified at the extension hearing on November 16th when asked about how did you feel when you received these messages. And she said, "I was afraid. I was afraid that he was going to come hurt me and hurt my property." She made that very clear on the record.
Getting back to the remand question.
Yes.
Are you sure you would want the hearing restricted to the current record, or are you saying the judge should open it?
I mean, I think the current record, what I am afraid to is to make my client have to go through more again.
No, but as a matter of law, the order you wanted would have expired because the first order after notice can only be for 1 year.
Right.
So
yes, I think
your client would have to produce new evidence in the ordinary course to get an extension of the first order after notice.
Right. I mean, I do agree with that. Yes, we would probably have to open it up to further testimony and about why her fear is still reasonable given the extent of time that has passed. And she will always be afraid of this person, and I believe she'll be able to meet the standard.
And let me just ask you one other question. The judge obviously was concerned about the collateral consequences on the defendant.
Yes.
Is it your position, I take it, that those are simply irrelevant? That that's a choice the legislature made, and judges, even if they're concerned about the collateral consequences, just can't take that into account?
It is, and I really want to add emphasis to that here and have this panel consider making a holding to that effect. So we know in Woolridge, the court has said you can't just enter an abuse prevention order because it'll do no harm, right? It won't have consequences on the defendant. And that's correct, and I 100% agree with that. But we don't have a holding anywhere that says the reverse. There's nothing that exists that says that the needs of the defendant who, even if found to be abusive, outweigh that of the plaintiff seeking protection from abuse when they meet the legal standard. It shouldn't be considered. It's irrelevant. Like 209A, since its inception, and case law says that, is designed to protect victims of abuse in the Commonwealth or protect them from the fear of abuse. If that's our legal standard that we have always upheld in all of our courts in the Commonwealth, Commonwealth, why would we consider the effects of that protection order for the person who committed the fear of abuse or the actual abuse? It's contrary to the intention of the statute, and it goes against protecting the person applying for the abuse prevention order, that his needs were considered by the judge over the needs of her, who he admitted was terrified of her. Her fear was palpable in the courtroom. And it's very rare, all of us who practice law in courtrooms, for a judge to acknowledge that and say that on the record. So I think what we need to focus on is how we protect not only my client moving forward from someone that she is terrified is going to abuse her in the future and what she felt at that moment, but also how we protect citizens of the Commonwealth moving forward who are in these same situations so that their needs as people who are afraid of abuse or have experienced abuse are protected over and above all else of the considerations of a judge trying the case. And I also want to comment that on the record, the judge really focused on if he had showed up at her house, if it had happened. And hindsight, you said this before, 2020, we have the benefit of that now, knowing he didn't actually show up, that he was intoxicated somewhere and making these threats. But at the time, she didn't know that, and she testified that it was real to her, and based on what she experienced with him in the past, she believed he was getting in his car and he was coming over and he was gonna hurt her. And that's where the imminence stems from. It stems from her totality of the circumstances and the fact that we have a direct message that says, I will be there in 15. And there's a reason why this court has chosen not to qualify at any point in time the definition of imminence, because imminence is so particular to the case and the facts of the case. Imminence could be, I'm showing up that day, I'm showing up this week, or you don't know when I'm showing up. But I would say if anything is going to meet the standard for imminence, saying I will show up in 15 meets that standard. It's imminent. She was afraid he was on his way over to hurt her and hurt her property and hurt her family. So by all definition, I believe that my client met the standard, and it should not, the judge erred in choosing not to extend it that day, both as a matter of law and misapplying the standard, and also as a matter of judgment in considering these extrinsic situations. And I'd be happy to answer any other questions. I know I'm running out of time.
I don't see any.
Okay.
We have your brief.
Thank you.
We appreciate your argument, and the case is taken under advisement. This case is submitted.
Thank you, Your Honors. Have a wonderful weekend.
And with that, our sitting for today is over. I'd like to thank our court personnel for their expert help, and the court is in recess.
All right, please. Court is now in recess.